Hello, and welcome to the Pennsylvania Medical Group Management Association's webinar. My name is Erin, and I'll be your host. As most of you may be aware, today was supposed to be the day that we were all together for our annual state conference, the Healthcare Leaders Summit. While we can't be together in person, we're glad to be able to connect virtually and to have our keynote speaker from the summit join us today. Regina is an entrepreneur, a philanthropist, a family man, a team player, and a leader who thrives on observing the masses and doing the opposite. He connects thousands of people a year strategically for the purposes of growing their business, which is not a typical model for growing a company. He has created a multi-million-dollar business that doesn't compete on price, and that's a classic blue ocean strategy. He's developed key strategies to remove the lid by being intentional, impactful, and reciprocal within his communities. We're very happy that he's joined us for a few minutes today, so please let's welcome Mike to the webinar.
Erin, thank you so much. Good morning, everyone. I hope that each of you are doing well, that you're healthy, safe, strong, and remaining grateful. So critical during these times. As Erin said, my name is Mike Regina. I'm the founder of MikeRegina.io. In addition to doing keynotes, I also do workshops and webinars, and also enjoy sharing just some motivational messages on all different social media platforms. So if you want to follow, I would love to have you at MikeRegina.io. So when I was asked to be the keynote speaker for the MGMA, which, by the way, I was completely stoked to be a part of, and just glad I'm able to just kind of meet you guys today virtually. I was asked to provide a presentation that touches on vision. Since it's going to be 2020, and 2020 refers to one's sight, one's vision, except for me because I have glasses, so I don't have the 2020 vision. The presentation that I was going to share with you today was called Clarity, which is an acronym that hopefully I'll be able to share with you this upcoming October. So since we are in uncertain times, I thought instead of sharing a little bit of tidbit on clarity, I would share an inspiring word to help you thrive during this time. So raise your hand if you're ready and if that sounds good. So 2 months ago, we all had goals, right? We had plans. We could see with somewhat certainty where we were going. Then, boom, here comes a freight train, COVID-19, hits us right in the face, and each of us have lost clarity on our 2020. We were blindsided and thrown into a world that none of us have ever experienced before. We could no longer see down the road because the smoke that was coming up from the fire that's taking place right in front of us has blurred our vision. So now what? Actually, so what? We transition. We adjust. We have to embrace going from seeing to believing and walking by faith. The definition of faith is being sure of what we cannot see. Challenge. So while we've lost our vision, you should not lose your clarity. What worked before to get you from point A to point B is no longer an option. So now we create, we innovate, we improve and learn that what we were doing before does not mean that it's what's right because we've been doing it for years. Me personally, I love change. I love mixing things up. I love being innovative and creative because it makes me better. I have growth. I break through things. I build confidence. Are you with me? Do you agree? Do you enjoy and embrace change? So as you go forward today, I want you to gain new clarity on your vision for 2020. So while the goals you might have had a month ago or 2 months ago might be the same, or they could have changed, who knows? One thing is for sure, the path and process has changed. Embrace change because change develops growth. Growth develops value, and value creates opportunity. So, what you thought was a crisis could now be your greatest opportunity. So, I want to encourage you to get after it, take it, and I want you to know that it's not going to be easy, but I can tell you it's certainly going to be worth it. Go forth and conquer. Happy to take any questions that you guys might have. So feel free to share. If none, I appreciate the time that I had the chance to spend with you this morning. If there's any questions that you do have, maybe not right now, but later, feel free to reach out to me, through my website at mikeregina.io. Happy to help in any way possible.
Thank you, Mike. I appreciate that. I hope that everybody is now a little energized to hear the second part of our presentation. We are going to switch over to George, and let me introduce our next speaker. George Slavic is also one of the speakers from the summit who will be joining us hopefully in the fall. George is a founding member of Hoffman, Slavic, and Easterly, where he practices exclusively in the areas of labor and employment law, handling traditional labor law matters and employment-related litigation, as well as counseling with regard to workplace issues such as sexual and other forms of unlawful harassment, employment discrimination, wrongful discharge, disability accommodations, family and medical leave, wage and hour, safety and health, employment contracts, non-competition agreements, and employee handbooks. George received his law degree in 1994 from George Washington University's National Law Center, where he was a member of the University Law Review and graduated with honors. He's also Phi Beta Kappa, magna cum laude graduate of Franklin and Marshall College, where he was an All-American member of the football team. We're very happy to have George join us now as well. George, you there?
I am here.
Great.
Ready to go?
Take it away.
Okay.
Go ahead.
Well, good morning, everybody. These are difficult times and challenging times, and I'm sure that everybody has been hopefully doing as well as they can be under the circumstances. I want to talk to you this morning about the employment law implications of this pandemic. As you can imagine, and I'm sure you're aware already, there are a myriad of employment issues that have popped up from the beginning of this pandemic to the present. And it seems like things are changing on basically a daily basis. Many times over the years, I would tell people I've been practicing employment law for over 25 years, and I would tell people that, listen, I've pretty much seen everything. There's not a question you can ask me that I probably don't know the answer to if it relates to employment law. Well, that's not the case anymore. I think there's a whole new category of employment law that is developing now. We would call it employment pandemic law. And it's something that we're all trying to figure out as we go here over the past couple months and as we move forward into the future. What I want to try to do today is just cover generally and somewhat briefly in each area the things that you're probably facing and a lot of the common issues that you're dealing with right now. I really probably need about 3 hours to do a good job covering all this stuff. What my goal is just to make sure that you're aware of everything, that you're thinking about these things, that they haven't sort of slipped through the cracks with respect to you and your practice or your where you're working in the medical field. So with that being said, how did we get here? Where did this start? Well, it started from an employment law standpoint back on March 19th when Governor Wolf issued his closure order, basically closing all non-life sustaining businesses throughout the Commonwealth of Pennsylvania. That obviously made people have to question, well, what's a life sustaining business? What's a non-life sustaining business? Where do we stand in things? Well, since you're all medical practices, you're all in the medical profession, the good news is that, good news is a relative term, but the good news in terms of being able to continue to work is that you are considered a life sustaining business. Basically, any medical office, physician's office, outpatient care center, diagnostic and medical laboratories, ambulatory healthcare services, medical and surgical hospitals, psychiatric and abuse hospitals. For the most part, any type of a medical practice is considered a life-sustaining business. Now, the only sort of caveat is that the governor carved out of that elective procedures are not permitted, that you are not permitted to continue elective procedures. That raises the question, what's elective? And I've had that asked by me a million times over the last month or so from all of my healthcare clients. And there is no hard and fast legal definition for that term, particularly as it relates to this issue, the pandemic issue. I can tell you that our advice that we've consistently given to our healthcare clients is that, the determination of what is elective is largely going to be left to the medical opinion of the physician. I really doubt that many courts are going to want to interfere in those types of decisions and second guess doctors in terms of, what's necessary versus what's elective. So I think in that regard, you're going to have a pretty wide berth in terms of what you can and can't do. In terms of what's not life-sustaining, well, an example would be dentists. Dentist offices are considered not life-sustaining, although they are permitted to continue to operate to do emergency or urgent type of procedures, provided that they're performed in accordance with the Department of Health's guidelines that were issued back on March 26th. You can, if anyone out there is in a dental practice, you can Google those guidelines, but I'm sure you're aware of them. But that would be an example of a non-life sustaining, medical practice. Trying to make sure that I get these buttons right on my computer. I apologize. So what's some critical terminology since the pandemic started? Things that probably most of us never really gave any thought to. Furlough, layoff, termination. Sometimes those terms have been used interchangeably. When this started, a lot of my clients, a lot of people calling me with questions were using them interchangeably, not understanding that they all have very different meanings. A furlough is very different from a layoff and a termination. A layoff is very different from a termination. What's a furlough? A furlough is an unpaid leave of absence. What does that mean? That basically means when you're on furlough, you remain an employee of the practice, of the employer. Your employment has not been terminated. You are an employee. You are an active employee. You're just not getting paid when you're furloughed. Okay. You continue to get benefits usually when you're furloughed. You continue to get healthcare benefits. You can use PTO if your employer lets you. You can, as an employer, force employees to use PTO or paid time off when they're on furlough. What's a layoff? A layoff is a situation where essentially we're terminating employment. You are not an active employee anymore. Your employment is actually being terminated when you're laid off. If your benefits are going to continue, the only way that's going to happen on a layoff is pursuant to COBRA and at your own expense. Now, because a layoff is a termination, that basically triggers any termination policies that you might have. So if someone's being laid off, they're entitled to payment for their accrued but unused PTO if that's what your policy states, if that's what your practice is. A termination is similar to a layoff in the sense that your employee's employment is being terminated. They're no longer an active employee. Their benefits don't continue. Your termination-related policies are implicated. Now, what's the main difference between a layoff and a termination? And again, people get this wrong all the time. With a layoff, there is an expectation you're going to be recalled. A layoff is a situation where, because of unusual circumstances, whether they're economic, pandemic, whatever they might be, we're having to terminate your employment, but we expect to bring you back when things get better. With a termination, that's not the case. When you are terminated, there is no expectation that you're going to come back. So you have to be careful how you use these terms with your employees. If you're telling your employees that they're laid off, but you have no intention of ever bringing them back, well, then you've misled them, and there could be some potential liability down the road when you don't ever bring them back and you start hiring new people. If you've terminated them and you've told them they're terminated, then, that's basically all they need to know. Now, what are some critical employment law issues related to furloughs and layoffs? Well, the most important are, how did you select the people to be furloughed and laid off versus the people that continued to keep their jobs? And if they're furloughed or laid off, how are you going to recall them? In what order are you going to recall them? How are you going to do that? Do you have an objective basis upon which you've done these things? And that's basically what you need to do to protect yourself from discrimination claims. So you had your entire workforce to look at and decide, well, who are we going to furlough and who are we going to keep? How did we do it? How did we pick the nurses or the techs or the receptionists or whoever they might be, the schedulers, the people that have been furloughed and laid off? And when things are starting to get better, how are we going to bring them back? In what order are we going to bring them back? Who are we not going to bring back? Those are things you have to think through and make sure that you have a legitimate, non-discriminatory, objective basis for doing all those things. Let's assume you're a life-sustaining business. What do we have to do at this point? We're operating, obviously, or maybe we're not operating at full capacity, but what are our obligations to our employees? Well, the most significant and critical obligation that you have as a business that continues to operate is to have a pandemic response plan. Now, that's been recommended by the CDC, and it's almost a requirement under OSHA. Okay. OSHA may not call it a pandemic response plan, but the requirements that OSHA imposes on us to provide a safe workplace for all of our employees essentially requires us in this time to have a pandemic response plan. Now, what does that include? Well, it includes guidance about cleaning issues, guidance about how we deal with employees that are symptomatic, asymptomatic, steps employees can take to be safe. If we're not a life-sustaining business, if you're not currently operating, the question for you in that regard then is, are you going to be prepared to reopen when the governor says basically all business can reopen, or we slowly start to allow other businesses to reopen? Are you going to be prepared with those same types of things that are covered in a pandemic response plan to ensure that you can reopen? Now, what are the requirements of a compliant pandemic response plan? Well, the first thing is it cannot be static. It has to be regularly updated and kept current with respect to changes that are happening. And if you are keeping track of things right now, things are changing on a rapid basis. It seems every day there's a new development, a new guidance from whether it's the CDC or the Pennsylvania Department of Health, or whether it's from the federal government or from the EEOC, whether it deals with ADA issues or EEOC issues or OSHA issues, or again, it's a litany of things. The four major requirements to have a compliant pandemic response plan are, number one, your plan has to inform employees of the recommendations that are out there in terms of what they can do to minimize their risk of infection from COVID-19. All those common sense things that the CDC has put out there, that needs to be in your pandemic response plan so that the employees can see, and it's right there in front of them, these are the things they should be doing. I'm sure you're all doing that already. The second major thing your pandemic response plan has to include is an explanation of what you're doing as an employer to protect your employees from COVID-19. What are all the cleaning protocols you're taking? What are you doing on a daily basis? Okay. What are the things that you do every single night? What are the things that you do periodically? But we need to let them know the steps that we're taking. The third thing that a pandemic response plan has to do is establish protocols for dealing with asymptomatic employees who may have been exposed to or had close contact with someone who has COVID-19. What are we going to do as an employer when we're told by an employee, or we realize that a particular employee has been in close contact with somebody, maybe living with somebody who has been exposed or has COVID-19? Our employee is currently asymptomatic. What are we going to do? We need to establish those protocols and communicate them to our employees. And then finally, the fourth thing is, what are our protocols for dealing with symptomatic employees? How are we going to handle those types of things? Now, the best news I can give you is that on April 15th, the Pennsylvania Department of Health issued guidance on how to satisfy all of those things for life-sustaining businesses. According to the Department of Health's April 15th order, here are some of the things that a life-sustaining business must do. These things need to be included in your pandemic response plan. Regularly clean and disinfect high-touch and high-traffic areas. Requiring employees that are working now to wear masks or face coverings at all times, except when they're eating or drinking. Providing access to soap, hand sanitizer, disinfectant wipes, other cleaning supplies so that they can protect themselves. Prohibit non-essential visitors, vendors, third parties from entering the workplace. Requiring employees to maintain and practice the social distancing recommendations that are out there while they're performing their jobs, to not be right on top of each other while they're performing their jobs to the extent that they can. I know that may not be possible in all circumstances. Staggering beginning times and ending times of work days and break times where practicable. Okay. Providing employees with space for their breaks and their meals, limiting the number of people that are allowed into common areas, whether they're locker rooms, break rooms, training areas, conference rooms, any particular area of your facility. If any kind of trainings or meetings have to take place, we try to do them by phone or by internet where possible, or we try to spread people out in the meetings. Establishing protocols for what to do when people have been exposed. And I'll cover that in a little bit more detail. Making sure that all of these things are communicated to employees in their native language. Okay. Further guidance from the Department of Health in the April 15th order. What if the workplace has been exposed to a person who is likely to have COVID-19 or may have COVID-19? Well, now we have additional and greater responsibilities to clean, disinfect all the areas that person may have come into contact with, focusing on the areas that are most frequently encountered by all the employees in the workplace. We have to then, if we're aware of the fact that the workplace may have been exposed to somebody who has COVID-19, identify and notify employees that were in, quote, close contact with that individual. Now, again, prior to this April 15th guidance, the idea of what close contact wasn't really defined. The Department of Health has basically said that close contact means they were within 6 feet of the person for at least 10 minutes from a 48-hour period from the onset of that person's symptoms until we found out about it. That's basically the definition of close contact. If somebody came into contact with them for a minute, under the Department of Health's April 15th order, that would not constitute close contact. But if we've had a situation where we've had exposure, the recommendation is to implement pre-shift temperature screenings, setting a baseline of what we're going to decide is too high and not allow somebody to come into work and actually send them home and have them self-monitor or self-quarantine. The number that I've seen floated out mostly, and you all probably know better than I what the best number is, but the number that I think the Department of Health has suggested is 100.4. Now, on top of the Department of Health's recent guidance, we have the CDC's guidance from April 8th that deals with what should an employer do with an asymptomatic employee that has had potential exposure to COVID-19. Again, similar, undergo pre-shift temperature testing and symptom assessment. If they have a temperature or showing symptoms, well, then they're going to be sent home. They're not going to be allowed to work. They're going to be self-isolated and self-quarantined. Have the person that's asymptomatic self-monitor for symptoms and advise the employer immediately if they begin to show symptoms. Obviously, wearing the face mask is no longer optional for Pennsylvania employers that are continuing to operate, but it is required. Practicing social distancing and again, routinely disinfecting and cleaning everything as we talked about before. Now, what if an employee is actually symptomatic? So it's not that they were just exposed, but they were exposed and now they're exhibiting symptoms. Again, according to the CDC, that employee needs to be sent home and advised to seek medical treatment. They're supposed to be self-quarantined for 14 days or for as long as their symptoms persist. Okay. if they can work from home, then we want to be able to allow them to work from home. I don't know how feasible that is in the medical field with respect to medical practices, but if they're able to work from home, then they would be able to work from home. There's a mention on the slide of the special leaves permitted under the FFCRA, which we'll talk about in a minute, but you're all probably not covered by that because of the healthcare provider exemption to the FFCRA. And again, with symptomatic employees, now we've got to clean, disinfect, notify other employees, all those types of things. When can a symptomatic employee return to work, according to the CDC? Well, according to the CDC, somebody is actually recovered when they've had at least 3 days without a fever or the use of any medication, and they've had improvement in their respiratory symptoms, either minimal or no cough anymore, and it's been at least 7 days since the symptoms first appeared. Now, they are required to have a medical release to return to work. You are permitted to require somebody to present you with that before you allow them to come back to work. Okay. I'm going to pretty much, I've covered these issues here as well. I want to jump to the Family First Coronavirus Response Act. What did the act do? It created leave entitlements for certain eligible employees of covered employers. Healthcare providers are exempt. So my guess is everybody that's on this call right now, you're exempt from the FFCRA. You're probably a doctor's office, hospital, healthcare facility, all the different things that I've put up here on this slide. Because of that, you are in all likelihood exempt. The exemption also applies to any individual employed by an entity that contracts with any of the above institutions, employers, entities. The Department of Labor has indicated it applies to anyone employed by an entity that provides medical services, produces medical products, or is otherwise involved in the making of medical equipment, drugs, et cetera, et cetera. So again, my guess is that you are all exempt from the FFCRA leave requirements for emergency sick leave and emergency family leave. What you're not, believe it or not, relieved from is the obligation to post the FFCRA poster in the workplace and provide notice to employees, even your employees, of what the FFCRA provides. Now, I don't really understand that requirement that the Department of Labor has imposed upon you. If none of your employees are entitled to the leave, I don't understand why you ought to be bothered with having to post the notice or send it out to employees. But I can only tell you that that is very clear from the act that you are required to do that. So what happened next? You know, we had the governor's order, then we had the FFCRA, then we had the CARES Act. That was the next thing that impacted the workplace. Okay. What was the CARES Act? Well, that was the act that provided financial assistance to employers, small employers of 500 employees or less, for the financial constraints that they are facing due to the COVID-19 pandemic. The most critical aspect of the CARES Act is the payroll protection program loans. Okay, I'm sure most of you, if you're not already familiar with that, you know, I would assume that most of you understand what those loans are and what they mean. Just so you know, initially $350 billion was set aside for funding the PPP loans. That funding was exhausted in 2 weeks. So the CARES Act became law on March the 27th. By early April, that $350 billion was gone. So if you snoozed and you didn't apply for one of those loans, you were left out temporarily. The good news is that earlier this week, the United States Senate passed what's now called the Paycheck Protection Program and Healthcare Enforcement Act, which provides an additional $310 billion in funding for these PPP loans. Okay, so The Senate has already passed that. It's expected that today the House will pass that, and that it will be signed into law by President Trump. If not today, then tomorrow. And if you are an employer that did not apply for one of these loans, you will be able to do so. Again, I'm not going to spend a lot of time on these loans because I think that you probably have heard all this stuff already, but a PPP loan can only be used for payroll costs, mortgage and interest payments and lease payments and utility payments, provided that the mortgages, rental agreements, utility agreements were in place prior to February 15th. It would not cover a new rental arrangement that came into place after that, or a lease that came into place after that, or a mortgage or a utility arrangement that came into place after that. Okay. Now, what is counted as a payroll cost? All employee salaries, wages, commissions up to $100,000 on an annualized basis. So if you have a physician out there that makes $300,000 a year, that does not mean that you can pay that entire salary for that physician for the PPP period and have it covered. You're going to have to prorate that on assuming that physician was making only $100,000 a year, and up to that amount of that person's salary can be paid by the PPP loan. Okay. Employee benefits are also included in that as well. The maximum amount that can be borrowed is 2.5 times the average monthly payroll costs for the last year prior to loan origination. That's capped at $10 million. What are the terms of these loans? They're 2-year fixed interest rate loans, 1%. All interest is deferred for 6 months. The critical portion of the PPP loan is that the entire amount of the loan can be forgivable. So if you borrow $250,000, provided that you use the loan the correct way and you meet all the requirements of forgiveness, that entire $250,000 can be forgivable and you will not have to pay any of it back. Now, how much of it is it forgivable? Well, all payroll costs and payments of mortgage, interest, rent, utilities, etc., made in the 8 weeks after the origination of the loan. That's the time period that it's covered. Now, when I say, all mortgage, interest, rent, etc., that's only the case provided that stuff doesn't exceed 25% of the total amount of the loan and the payroll costs. So you cannot, the payroll costs need to be, when I say payroll costs, the salaries, the commissions, the wages, the bonuses, those types of things have to make up at least 75% or more of what you're using the loan for. You can pay those other things off as long as it doesn't exceed 25%. But again, remember, it only applies to the 8 weeks after origination. If you've been paying salary up to this point, and say you're getting your loan tomorrow, well, the payroll payments you've been making up to this point are not covered. Okay, that's not going to be something that's forgiven and that you're going to use the PPP loan for. Okay, it's only the 8-week period after origination. Okay, can the forgiveness amount be reduced? Meaning, is it possible that you're going to take out a loan for $500,000 under this program, and that you're going to have to pay back some amount of it, that the whole thing won't be forgiven? Yes, that's very, very possible, depending upon your head count, whether you've let people go, whether you've reduced people's salaries, and whether or not you've brought, fixed, remedied those situations prior to June 30th. Okay, if you've remedied those situations and fixed those situations prior to June 30th, then in all likelihood you'll have 100% forgiveness. But if you have not, then you may very well have a loan that you're expecting to be forgiven, which is not going to be forgiven. So you need to make sure. And I can tell you this, we have, my law firm was able to secure one of these loans, and we have very detailed payroll and expense paperwork that we have to fill out on a weekly basis, and then provide that to our lender so that we can make sure that we are going to maximize the amount of our forgiveness. And I would suggest that you do the same thing. Again, something that I don't want to spend a lot of time on is which also was part of the CARES Act, but it was the HSS, the Health and Human Services Provider Relief Fund that was created by the CARES Act, which again, I'm sure as healthcare providers, you're all very familiar with this fund and the monies that are being distributed from this fund. Originally $30 billion, another $75 billion has been thrown on top. That happened just this week. Basically, any healthcare facility provider that receives Medicare fee-for-service reimbursements or that received it in 2019 are eligible for these payments. Okay. Basically, what do you need to know about it? It's pretty self-explanatory on the slide, but all facilities and providers that received Medicare fee-for-service reimbursements in 2019 are eligible for these grants, and they are grants. They do not have to be paid back. Okay. The terms and conditions and the eligibility factors for these grants have been interpreted very, very broadly. Okay. Independent physicians will be, if you haven't already, you will be receiving these payments directly. If a physician is employed by a group practice or a hospital, they will not receive the payment directly. It will go to the group practice or the hospital. Whether it's the independent physician or the group practice that receives the payments, you need to sign the attestation confirming the receipt of the funds and agreeing to the terms and conditions in order to receive them. Okay. If you do not return the correct paperwork, if you accept the funds and don't return the paperwork for a period of 30 days, you are presumed to have agreed to the terms and conditions. Okay. So they want you to return the paperwork, agreeing to the terms and conditions. But if you receive the money and then subsequently don't return it, the fact that you kept the money for more than 30 days is a presumption that you agree to it. Okay. And again, as this next slide says, HHS has broadly interpreted the eligibility for the grants. Pretty much every single healthcare provider that received Medicare fee-for-service reimbursement in 2019 will be eligible for that. Okay. The one thing you cannot do is any type of balanced billing for out-of-network COVID-19 patients. Okay. That is a no-no, and you cannot do that. Okay. You also have record keeping and documentation obligations as part of this provider relief fund as well. Now, I want to switch gears, get away from some of the new things and basically cover some of the older concept and issues that are popping their head up now due to the pandemic in the area of employment law that are going to potentially create problems for us. Briefly, what are the main areas? OSHA, the ADA, workers' comp claims, potential negligence claims for employees that claim, or for patients or customers that claim that they became infected with COVID-19 at your facility, at your practice because of your negligence. Fair Labor Standards Act issues and discrimination claims. Let's start with OSHA. Okay, OSHA is still out there. You still have the same obligation that you always had to provide a safe workplace for your employees. Well, obviously, the requirements of providing a safe workplace have significantly changed in this COVID-19 pandemic timeframe. Okay, there's no federal standard or OSHA hasn't adopted any kind of new standard for COVID-19. But as I said earlier, the Pennsylvania Department of Health has issued guidance. The CDC has issued guidance. And if you have the appropriate pandemic response plan, you will then, by definition, meet all of the requirements that you have under OSHA for providing a safe workplace. But you are going to have employees who are going to complain about what you're doing. And they're going to complain to OSHA that you're not providing them with a safe workplace. And you're going to have to deal with those OSHA complaints. Okay. When you get an OSHA complaint, remember, and I'm going to date myself with this reference, but you're not Magnum PI. You're not Simon & Simon. You're not Jim Rockford. Some of you are going to know how old I am now. But your job is not to try to ferret out who made the OSHA complaint. And you're pissed off that somebody made the OSHA complaint. And even though you feel like you're going above and beyond, taking every precaution possible, someone has now complained about your practice to OSHA, and now you have an OSHA investigator calling you. Don't worry about who made the complaint. The last thing you want to do is put yourself in a position where it looks like you have now retaliated against somebody for contacting OSHA. You just want to communicate directly with the OSHA investigator, share with them your pandemic response plan, share with them all the different things that you're doing. And again, assuming you're doing all those things correctly, you're not going to have any problem with OSHA. It's not going to stop employees from complaining, but you're not going to have any problems with OSHA if you're doing those things. Okay. Now, the next slide basically is talking about the pandemic response plan and making sure that you have all those things covered as well. Are you making sure that your employees are aware of the pandemic response plan, aware of the cleaning protocols, aware of any kind of trainings that you're doing? Are you making sure that you have kept the necessary records that you need to keep of the different things that you're doing from a safety and a cleaning standpoint and a safety protocol standpoint? If anybody has tested positive that we're aware is actually had COVID-19 in the workplace, has that been reported? Have we kept the records of that? All those types of things we're going to have to do as it relates to OSHA. Okay. Now, switch gears from OSHA. Let's talk about some just general discrimination type of issues you might have to deal with. If you're operating right now, the Department of Health says your employees have to wear a mask, whether you're the person doing the takeout for Starbucks or you're the receptionist for your medical practice. You have to wear masks while working. You have an employee that says, I'm not going to wear the mask. I have a religious objection to the mask. I can't wear the mask because of health issues. What's your obligation at that point as it relates to that employee? Can you just force them to wear the mask? Can you terminate them for not wearing the mask? Well, the answer is you have to engage in the interactive process that you've always had to engage in when people make accommodation requests at work, whether they're for religious reasons or ADA reasons. You have to find out for them, well, what's the reason that they can't wear the mask? Is there any other alternative out there other than wearing the mask that would enable them to still do their job for you? Now, according to the Department of Health, the answer is basically no. Right now, the answer is no, not under the current state of things. If somebody is going to object and say they can't wear it, in all likelihood, they're not going to be able to work for you. Now, can you terminate them? Well, that's a pretty extreme step. Maybe we're going to put them out on a leave of absence. Obviously, we've been putting a lot of people out on leave of absence, furloughs, layoffs, things like that. Perhaps that's what we do, at least for a short period of time, to see how long the mask requirements are going to be in place before we decide that we're going to terminate someone. Now, if somebody was disrespectful and insubordinate and acted unprofessionally in the way they handled themselves in terms of objecting to the mask requirement, that may be a different issue. And maybe we're going to be able to take action against somebody for that reason, not necessarily the underlying accommodation request. So I talked about the ADA a little bit there with that example. Let's talk about other ADA type of issues. Before I get to this slide, let's just talk about something that's happening a lot right now. You have an employee who suffers from anxiety. They've been diagnosed with anxiety, and they're telling you they can't work because of their anxiety. They're too scared to come to work because of their anxiety. Well, we have, again, the same obligations under the ADA that we always did in terms of trying to accommodate, if we can, somebody who has this condition. And perhaps the answer is a leave of absence. Obviously not a indefinite leave of absence or a lengthy leave of absence, but and a leave of absence under these circumstances might not be possible. I don't know. It's going to be determined by the specific facts and circumstances that are in place at your particular medical practice, your facility, based on your staffing needs, based upon your workload. All those things are going to come into play in terms of whether or not we can accommodate somebody who is unwilling to come to work because of fear of the virus. And I know I'm going to jump ahead here now, but I think it's an appropriate time to do so. I'm sure some of you are thinking to yourself, well, if I have somebody that won't come to work because they're afraid of the virus, and I furlough them, or they go out on a leave of absence, can they collect unemployment? Well, generally the answer would be no. They cannot collect unemployment. Why? Because they're not ready, willing, and able to work. Work is available for them. They are declining to come to work. They have a medical condition, according to them, that precludes them from working, the anxiety. Well, that would preclude you from collecting unemployment compensation. Our esteemed governor probably will disagree with that, but I don't think he is as familiar with our unemployment compensation system as I am. But generally, under normal circumstances, that person would not be entitled to unemployment compensation. Now let's talk about some other ADA issues that have popped up. Can we ask employees medical questions now, pre-shift, as a condition to coming to work? Yes. The ADA generally prohibits it, but because of the pandemic, these questions can be asked. Do you have COVID-19? Have you been tested for COVID-19? Are you exhibiting any symptoms of COVID-19? Do you have a fever? Are you coughing? Are you having any difficulty breathing? Do you have any contact with people that have COVID-19, that have been exposed to people with COVID-19? These are all questions that we can ask our employees now, whether it's generally or every single day on their way into the workplace. Okay. Now, you can't single out people for these questions unless you have an objective reason to do so. There's no problem if you're going to ask the questions to everybody. In that case, you don't have to have any kind of suspicion or reason to do so. In the pandemic environment that we're in, you can ask those questions generally of everybody. But if you're not going to ask them of everybody, if you're going to single people out, then you have to have a reason why you're singling this person out, an objective, reasonable belief. Maybe it's because you have knowledge that their spouse has COVID-19, their significant other. Maybe it's because of someone they came into contact with at work. Maybe it's because of they're symptomatic. But you can't just single people out based on their age and say, well, we're only going to ask these questions of people that are 65 years of age and older that work for us. Can't do that. That's age discrimination. You can't single out people on the basis of pre-existing medical conditions. Okay, those are things you can't do. Now, temperature checks. Again, generally in a normal environment, you can't check people's temperature on their way in and out, on their way into work in the morning, and then preclude them from access to the workplace if they're showing a temperature. You can now. In this environment, the ADA permits it. The sort of the pandemic exception permits it. Okay. I think you just have to be cautious with temperature checks. You medical providers out there know better than I do, but just because someone's showing a fever, showing a temperature, an elevated temperature of 100.4 degrees or higher, that doesn't mean they have COVID-19. There are probably a lot of other reasons why they may have the fever. But in the non-medical field, I can tell you that a lot of employers are now doing this. Whether it's the right thing to do, the wrong thing to do, they are doing it. You can do it in your workplaces as well. Obviously, consistency is the key. We have to make sure that the people that are doing it, again, and I don't think this really is a problem for you, the people on this call, but that they know what they're doing, that they understand how to read it. To the extent that we're doing it, we need to keep track of it. We need to keep track of the results. The screening should be done in private. It shouldn't be, people as they walk in the door, we take their temperature and everybody behind them sees the results, or we're announcing the results of someone standing next to us. Okay, Jim 98.4, Mary 102, or Mary 100 point whatever. I mean, we have to make sure that it's done in private. If we are documenting the results, they have to be kept separate from the employee's personnel file. So if you're keeping a separate record every day for each individual employee, that needs to go in their medical records file. It cannot go in their regular personnel file. Fair Labor Standards Act issues that we're dealing with right now. The first one that's not even on your slide, you have salaried employees, exempt employees that you've reduced their workload. You've cut them down from 5 days to 4 days. You've furloughed them. 1 week they're working, or they're furloughed 1 week and then working 1 week, or they're furloughed 2 days and working 3 days. Remember that you cannot dock an exempt employee's salary who has done any work in the week for you. They have to get paid their full salary for that week. I had a medical practice client, a fairly large hospital, making a very grievous error as it relates to their salaried exempt employees. They were furloughing them for a day or two at a time during the course of a week, and saying to them that, you can use PTO to cover those 2 non-work days or take it as unpaid. With an exempt employee cannot take an unpaid day when they've already performed work for you during the week. They must be paid their full salary. Now, if you want to make them use PTO to make up for the days they're not working, you can absolutely do that. But you cannot allow them to take an unpaid day and therefore reduce their weekly salary because they only worked 4 days. The whole point of being exempt and getting paid a salary is that you get the same salary every single week, regardless of the number of hours you work in a week. Now, if you furlough someone for an entire week, an exempt employee for an entire week, and they don't do any work the entire week, then you're okay. Then you don't have to pay them for that week. You can allow them to use PTO for the week if they want to, but if they want to take a full unpaid week, that's fine. But you cannot, under any circumstances, dock their pay if they have only worked a day or two during the course of the week. Once they've performed any work for you for the week, they're entitled to their full salary. And when you start to do that, like I said, that hospital that I was talking to you about, the danger that they have is now they have 2 things. One, the employee is arguably permitted to file a FLSA claim for the day that they took as unpaid. They should have been paid for that day and be entitled to reimbursement for that money. In addition, by treating them that way, you're essentially treating them as a non-exempt employee. And therefore, you could have forfeited their exempt status. And now going forward, they're entitled to overtime for any hours that they've worked in over 40 hours in a work week. Okay. Other potential FLSA issues, work from home issues. You have, and again, I don't know how applicable this will be for this group as healthcare practitioners and providers. I don't know that it's possible for a lot of your people to do work from home, but maybe it is. Maybe they're doing work from home. To the extent that you have non-exempt employees working from home, you have to make sure you're compensating them properly. Are they accurately keeping track of all their time? Are they recording their time? Are you paying them for all their compensable time? Or, it's difficult because you don't know how much they're actually working from home when you're non-exempt. They submit a timesheet for 7 hours. You don't know really what they did for those 7 hours. They submit a timesheet for 2 hours, and you have to wonder, well, did they do more work than that? We just have to make sure that we communicate to our non-exempt employees working from home that they are entitled to payment for all work they do at home. That means responding to an email, responding to a phone call, doing a report, doing research, whatever it is. They're entitled to compensation. We don't want them to under-record their time. If they get the sense from you, if you start to put out very strict restrictions on what's permissible to be paid or not, you may run into some problems in terms of whether or not you're paying them properly. employees that we're doing temperature checks for on their way into work. We've been asked this a lot. They have to sit there and wait to get into the workplace while they're getting their temperature checked. Are they entitled to be paid, the non-exempt employees, for their time waiting to get their temperature checked? I would assume the answer for most of your medical practice, I can't imagine that the time is anything more than de minimis, that they're waiting more than a minute or two to get in. If it's a lengthy type of thing, they're waiting 10, 15, 20 minutes, then I would say, yes, you're going to have to pay them for that. And you're going to have to make sure that they're aware of it. And what's a way to avoid that is stagger the start time, which you should be doing anyway under your pandemic response plan, where you don't have 100 people coming in at one time, or even 50 people coming in at one time. You have 15 people now, 15 people 15 minutes from now, and 15 people 15 minutes from then. It's not going to take very long to take 15 temperatures. So we won't have any FLSA issues in that regard. Okay. If an employee refuses to take a temperature check or get their temperature checked, can you refuse them entry into the workplace? Absolutely. You do not have to allow them to come into work. All right, so let's switch to workers' comp claims, negligence claims. You have an employee that believes they contracted COVID-19 at work. Can they sue you for negligence and say, I only got this because you didn't take the steps you were supposed to take? You didn't take the precautions you were supposed to take, and because of that, I got COVID-19. The answer is generally no. It's determined by state law. Under Pennsylvania law, their sole remedy would be a workers' comp claim. If they believe they contracted COVID-19 at work, their sole remedy is workers' compensation. You would need to allow them to file a workers' comp claim, notify your workers' comp carrier. Now, can they still bring a negligence claim against you? Absolutely. It's happened to Walmart in Chicago. It's happened to other employers throughout the country. But the workers' compensation defense should be out there for you. You should have an affirmative defense to that claim that, listen, they're precluded from bringing this negligence claim. It's precluded by workers' comp. Now, just an aside, I think it's going to be difficult for employees to actually prove that they contracted COVID-19 at work, considering they could have contracted it anywhere, in the parking lot, talking to their neighbor in the grocery store, in the Starbucks, line, whatever it might be, taking their takeout. So they can bring these negligence claims against you, but in all likelihood, they're going to be precluded under Pennsylvania law by workers' compensation. Now, the last thing I want to talk to you about today is unemployment compensation. Okay, how has unemployment compensation changed? Well, the waiting week is out. The work search and work registration obligation is out. Under the CARES Act, the pandemic unemployment compensation provides you with an additional 13 weeks of unemployment compensation. The federal pandemic unemployment compensation allows you an extra $600 a week on top of whatever you're getting from the state government. Okay, the extra 13 weeks that runs through December 31st. The extra $600 only runs through July 31st. But basically, what that means is if you have an employee who you've cut their work week, they're down from 5 days to 2 or 5 days to 3, they may be able to get partial unemployment. If they are able to get partial unemployment, they would be eligible for the $600 federal assistance. Okay, regardless of whether or not the partial unemployment is only $100, they get the extra $600 on top of it. Okay, if you have an exempt employee that's furloughed for an entire week, well, they are certainly eligible for unemployment compensation for that week, and then they would be eligible for the $600 on top of that. The pandemic unemployment assistance also extends the rules about who's eligible. Normally, self-employed people wouldn't be eligible. Normally, independent contractors wouldn't be eligible. There's been some changes to that with respect to the CARES Act and who is actually eligible. Again, if you have somebody that's furloughed or laid off, their hours are cut, they're definitely eligible for unemployment compensation, provided that the other eligibility factors are met. What do you do when somebody is on unemployment? You furloughed them. You're ready to bring them back. Things are starting to kick back up. We're getting more patients in. The restrictions are being lifted in terms of what we can do. And now we're saying to our employees, hey, it's time to come back. And they say, well, I don't want to come back. I'd rather collect unemployment. I'm better off on unemployment. Why do I want to come into work to a medical practice, be exposed to people that could be sick when I can sit out and collect unemployment? I'm actually doing better, collecting unemployment, taking the federal bump. No, thanks, but no thanks. Normally, as I said, you would be, under these circumstances, ineligible for benefits. You're offered a job and you're turning it down. Believe it or not, our governor 2 days ago in his press conference announced to the entire Commonwealth of Pennsylvania that no, these people should be able to continue to collect unemployment. Of course, they could collect that. If they're better off under the unemployment system, they feel they're doing better under unemployment, then they can collect unemployment for as long as they collect unemployment. And the governor was asked the question, well, how do we encourage our people to come back then? And his rather flip answer was, pay them more. Pay them more. So again, I really don't believe that the governor understands the unemployment compensation system in Pennsylvania. It remains to be seen how the unemployment compensation system will deal with these types of employees. They should not be entitled to benefits if they refuse to come back to work. But if the governor is going to instruct the unemployment compensation office to pay these claims, well, then they're going to pay the claims. It's not up to us. It's not up to employers. We don't get to make the eligibility decisions. Okay. We only get to provide information to the unemployment compensation office to help them make those decisions. And in these situations, I encourage employers to do just that. There's a special form out there called the UC 1921W, which allows you to inform the unemployment compensation office of a situation where an employee has been offered a job to come back to work and has turned it down and has refused to come back. Obviously, if employees are granted benefits, you always have the right to appeal those benefits and appeal the benefit determination. So the last thing is, again, you run the risk of potential discrimination claims. I've already alluded to this earlier, so I'm not really going to say anything more about it. How did you furlough people to begin with, and how are you going to bring them back? Somebody's going to say, well, wait a minute, it looks like you're only bringing back the younger people. It looks like you're bringing back only the Caucasian people. It looks like you're only bringing back the non-disabled people. You have to have a plan for how you bring these people back. Okay. And then the final point, I guess, is, and believe it or not, I'm seeing this, and I've had questions about this over the past couple of days. Employees being harassed at work by other employees because they suspect they're COVID positive. They suspect they've been exposed. They heard that they're taking reckless steps. They're not self-quarantining at home. They're not social distancing at home. They're posting pictures on Facebook, flaunting the rules. And now these employees are upset that they're coming to work and now subjecting them to potential exposure, and they're harassing them. Well, we've got to be careful and make sure that people are not being harassed because they're being deemed to be disabled, or they're being harassed because of their status as somebody who may have had COVID-19. These are things that we're going to have to talk about, and we may have to revisit harassment issues as it relates to our employees. So with that, Aaron, we can move to the question and answers. I don't know if anybody has any questions. I know that I went longer than the 45 minutes I was allotted. I apologize for that. It's a lot of material to cover, but to the extent that anybody has any questions, I'm happy to stick around for a couple minutes to answer any questions that might be out there.
Yes, we certainly do. First, George asks, two parts here. Should we terminate employees who are in a high-risk group, and are businesses at risk for litigation if we ask at-risk employees to come back to work and they contract COVID-19?
We absolutely cannot simply terminate people because they're in high-risk categories. That would not be a good idea. Okay. If those people would like to have a leave of absence, or they don't want to come to work, or whatever it might be, and you're able to do that and accommodate that, then go to town, go ahead. But we cannot just simply terminate them and assume that they're going to get sick because they're in a high risk category. As far as are we at risk for claims by allowing them to come back and then they contract COVID-19? No, I don't believe that you are. Again, if you're taking all the precautions that you're supposed to be taking, you're satisfying your obligations in that regard. The employees that are being called back to work understand what the risks are. If they, again, want to request time off, request to be furloughed, request to be laid off, they're certainly able to do that. But if they decide to come back and they happen to contract COVID-19, as I said at the end, their remedy would be solely a workers' comp claim. There would be no exposure to an employer beyond that.
If elective procedures are 80% of our business, are we still exempt from the emergency FMLA and paid sick leaves?
Yes, you meet the definition of a healthcare provider. You're a doctor's office, you're a medical practice. The fact that you don't have work right now, or that it's significantly been reduced, doesn't change that.
What if salaried employees have a contract and they agree to modifications to the salary for a specific period of time?
Then I would say you're okay. I mean, I would do an amendment to the written contract, the written employment agreement, whatever. I would do an amendment where both parties agree that, for a period of time, I agree to a reduced salary, et cetera, et cetera. As long as you put that in writing, I don't have any problem with it, and the employee signs off on it.
I think you hit this right at the end. If we have an employee who refuses to return to work when they're called back, how do we report that to unemployment? Yeah,
you use that form I mentioned, which is, you can find that online. Pennsylvania Department of Labor and Industry website. You can find that form online and you send it in. Now, again, thanks to the governor, this is going to be a problem for a lot of employers. I can't tell you the firestorm that his comments created the other day. I probably had 50 employers in the last 2 days contact me with these same issues. And the only thing I can say is, again, these people should not be entitled to unemployment. And this is not political. Don't anybody misunderstand what I'm saying. I'm not trying to begrudge anybody benefits, but the way the law's set up, if a job is offered to you and you turn it down, you're not eligible for unemployment. It doesn't matter that you can make more under some sort of special unemployment plan that exists. So yeah, that's the way to do it, Aaron.
Paul asks for clarification. A salaried nurse practitioner cannot be forced to work 32 hours with 8 hours unpaid if she does not want to use PTO. Also, what if she agreed to this by email?
Doesn't matter. You can, again, now assuming I assume a nurse practitioner is exempt, meets all the requirements of exempt status. I assume that because they're being paid a salary, that you've been treating them as exempt, and not paying them any overtime. And under that circumstance, no, an exempt employee cannot voluntarily agree to take less than their normal salary because they're only working 32 hours as opposed to 40. Remember, the whole point of being exempt is the number of hours you work should be irrelevant to your salary. It should have no bearing upon it. Whether you work 32, 40, or 100 in a week, you're getting that same salary every single week. So it doesn't make a difference that they agreed to it in an email in writing. That can still come back and bite you in the end. I would, if it were me, I would force them to use PTO for the day. Otherwise, I would just pay them their full salary.
So the email offers no protection to the health system?
It does not.
And maybe you could help us with this. Mary Beth asked for a link to the form that you're talking about, the unemployment form?
I mean, I'm sure I could find it. I don't know how I get it to everybody, but again, Aaron?
It's pretty standard available.
Yeah, I mean, I'm pretty sure, like I said, if you just Google Pennsylvania Department of Labor and Industry, unemployment compensation form, whatever, my guess is it's going to come up. If people have problems finding it, I think on these slides, you have my email. Shoot me an email and I'll have somebody send it to you.
Okay, we'll do that. Are there any other questions for George right now? Give a second for any last minute thoughts.
I just want to thank you. Thank you for having me.
We have one more, George.
Okay.
Can employees be required to use their PTO?
Yes. Yeah, you can require an employee to use their PTO. There's absolutely no issue with that whatsoever. Now, again, I'm assuming you're a Pennsylvania employer and the employee works in Pennsylvania. If the employee works in some other state, there are some other states that have limitations on that. Okay, but generally, the answer in Pennsylvania is absolutely. You can force people to use their PTO. They're not entitled to PTO to begin with. PTO is an employer-created benefit. You can manage it and implement it any way you want.
Oh, we got one more. I have an employee that we had to decrease hours at the health center, and we offered her to go to another health center to work. She refused because she said she wanted to be laid off because she felt that the center was in a high-risk area. What do we do with her?
The other location we want to send her to, I would need to know a little bit more, unfortunately. I mean, if they're both our locations, she doesn't have any option to turn down the other assignment just because it's at a higher risk location. If we're asking her to go work for another employer and they're going to pay her, then I don't think she has to do that. If that's what the question is.
But I think they're both from, another health center. So if it's the same company, just a different location.
Yeah, if I have a location in Harrisburg and a location in, New York City, and I say to the person, congratulations, I'm reassigning you today to our New York City location, they don't really have a choice to turn that down just because it's, at the epicenter of the country's COVID-19 pandemic crisis. If that's where you're sending them, that's where you're sending them. Now, again, I wouldn't blame somebody for saying, hey, I'm not going there. But from an employment law perspective, you have the right to send them there if they don't want to go there. And then, ultimately they're terminated or their hours are reduced because of that. They would not be entitled to unemployment.
Great, thank you. Well, I want to thank George and Mike and all of our attendees for coming together today. This concludes our webinar. Thank you all for your participation, and please have a safe afternoon.